Court call the case of the People versus Lisa Keebler.
Office for the people.
John Shea, Your Honor, with and on behalf of Lisa Keebler.
Lisa Keebler. Morning, Your Honor. I think it's still
Okay.
Bruce Clare on behalf of probation, Your Honor. Ms. Keebler, before the court today for violation of probation. Ms. Keebler, long time, a new arrest was in 71, daily offense of December 2025. There is alleged use of alcohol.
This case starts quietly, but don't be fooled. What you're watching is a probation violation that could spiral into a felony with life-altering consequences. A defendant already on thin ice, a new OWI arrest, alcohol involved, and a court forced to choose between incarceration and control. The real question isn't what happened on December 5th, it's whether the system believes supervision can still work when public safety is on the line. Stay with us because this courtroom is about to make a critical call.
On that date, I did not know the PAC when I provided that petition support for this hearing, but learned of it this morning that blood alcohol was a 7. So the court was aware of it for multiple times, either the addition of a probation that was placed on her on December 11th, 2025. She's had no violations on that scram tether since. Given that the case is still pending, probation is recommending that the scram tether continue. That Ms. Keebler not go into any places that serve alcohol. That she have an interlock placed on her vehicle through Nationwide. That being today, she record there directly after this hearing. And that the violation hearing continue or be adjourned to January 28, 2026 at 12 p.m. awaiting the new case being filed.
And Your Honor, for the record, I did review that new case, and I can confirm as of this morning, I reviewed the charging documents and the necessary warrant packet information.
It's Florida. She's back. She's okay.
To charge an OWI third offense. It is an OWI third offense. I see that the defendant's priors are from 2014 and 2025. So in that case, I have requested $25,000 cash or surety bond for that arraignment. It's a separate issue. In this case,
this is where the stakes jump dramatically. An OWI third offense isn't just another traffic case, it's a felony-level problem with serious prison exposure. The prosecution's mention of a $25,000 cash bond signals they see this as an escalating risk, not a lapse in judgment. Add a single vehicle crash into a ditch, and suddenly this isn't about mistakes, it's about patterns. Ask yourself, how many chances should probation allow before accountability turns into confinement?
because the defendant was on probation for an OWI-related case, and then picked up another one with a single vehicle crash into a ditch, people are requesting that she be reinstated.
And as to the violation at this point, you're going to admit to that violation. Is that correct?
Yes, Ms. Keebler is going to admit that she used alcohol on December 5th, and she will admit that she was arrested as well on December 5th. She is not making any admissions regarding how much she had to drink or anything like that, given the fact that we have a pending felony matter that's charged arising out of the same incident. But she doesn't have a problem acknowledging that she used alcohol that day.
Is that correct, Ms. Keebler?
That's correct.
All right. And the court will accept that admission. So that the record is very clear and that the crux or the majority of the in-chambers conference held with counsel and probation was revolving around, without getting into too much detail, certain cognitive issues and certain other medical issues regarding this defendant. And the court was significantly weighing and balancing a remand as opposed to some other type of process that could, or something that could be put into place, which both, fundamentally would stop the defendant's consumption of alcohol, but at the same time, which is paramount to the court, that ensure as best the court can the public safety. And I felt, after having heard from everyone, that the court's normal practice, which particularly this time of year might be a remand, that the court felt that, given all of those circumstances, that another process could be put into place. That doesn't mean at a later date I might not decide that a remand might be appropriate. But at this particular moment, I'm looking to do something a little bit different that more fits with this particular defendant. Paramount in that, and one of the things that was stressed by probation and also counsel for the defendant, was the fact that when there is stringent monitoring of the defendant does very well, and there is not the consumption of alcohol. It's when there is.
This is one of the most revealing moments of the hearing. The judge isn't minimizing the danger, she's dissecting it. Alcohol alone is a problem. Driving alone is a problem. Together, they're catastrophic. What stands out is the court's emphasis on structure. When monitoring is tight, the defendant succeeds. When it loosens, relapse follows. This isn't leniency. It's a calculated attempt to interrupt a cycle before it turns fatal. Would you trust supervision over jail here?
Sort of a gap there that the alcohol happens. And so two primary issues for the court are the consumption of alcohol and then the operation of a motor vehicle. And when those two come together, that becomes even more of a problem. So I think we fashioned something that will address that, at least temporarily, for the time being. So what I'm going to do and what I'm going to order is I'll continue the scram tether. I will order no driving or operation of motor vehicle without an ignition interlock. I'm going to order that ignition interlock be placed on that vehicle today. You are not to drive any other vehicle that is not equipped with an alcohol ignition interlock. Do you understand that?
I do.
I will adjourn or set for a review, I guess, or continuation of the BOP hearing to January 28, 2026 at 12 p.m. I'm also going to order that you are not to enter any establishment that either sells or serves any type of alcohol. And I realize that may preclude the entry into grocery stores and other places like that, but that is going to be the order of the court. You cannot go in. If grocery items and other things need to be ordered, they could be ordered. I would not find a violation if you were in the parking lot picking up and there's a pickup of something along those lines. However, you are not to be in those establishments. Is that understood?
I understand.
Is there anything else?
She admitted the violation jail was on the table. Instead, the judge locked everything down: movement, driving, alcohol, choosing control over incarceration.
In the end, this court chose control over incarceration. But make no mistake, jail was absolutely on the table. The judge imposed strict safeguards, continuous alcohol monitoring, zero tolerance for driving without an interlock, and total exclusion from alcohol-serving locations. It's a conditional second chance, not forgiveness. The message is clear: one misstep and the balance shifts. If you found this case as intense as we did, hit like, share your thoughts below, and subscribe for more real courtroom breakdowns.
Mr. Shea, anything else?
I'm just taking notes, Judge. No, nothing else. Thank you very much.
All right. Thank you. All right. Good luck to you.
Thank you, Judge.
They're waiting you down at AAA for the install.
Yes,
You know where those are?
I'll give them the address.
Keep going down Michigan Avenue. You'll see a yellow sign that says AAA. You'll see it. Yeah. Okay.
Okay.
All right. Thank you.
All right.
Thank you, Judge.
Thank you. Court does call the case of the people versus Justin Lang.
Ashley Pelvis for the people.
Good morning, Assistant Public Defender Lauren appearing on behalf of Mr. Lang. Mr. Lang is not present. He advised me this morning that he is in the hospital at St. Joe's. He had a seizure. He did provide me with a copy of his bracelet thing.
Oh,
I don't know what they call it, but we did provide
the admission bracelet.
Thank you. Yes, and I did show that to Ms. Feltus. I did provide a copy of Ms. Hartwig's, or I don't know if we want to put the file, but that is the latest update I have.
Were you satisfied with the picture, Ms.
I'm sure it is what it is, Your Honor. I have no reason to doubt what Ms. Pyrenee is saying. I know the court recalls we set the state because Mr. Lang was going to be local because he does currently, I think, live in Texas, if I recall correctly.
Houston, yeah.
Houston, Texas, yeah. For what it's worth, I have not been able to have good contact with the apartment folks for this hearing. If the court recalls, we were hoping to get some information from Hamptons or Pines at Cloverleaf. I can't recall which one off the top of my head right now. So at that point, I think I would just request an adjournment so we can have everybody here and see if we can get an answer and can ask them for a bench warrant.
All right. Non-jury trial in this matter. But he lives in Texas. How often is he up here? Do you know? Yes.
I know he was here because of the
Holidays. Right. Well, why don't I do this and we can see if everything will work out. I'll just, when's my,
And then see February 28th. I'm sorry, January 28th. And
I know that date is causing some difficulty for my office, so I was actually going to ask if we could look at February. If that would be okay for in defense.
for your office?
Yes.
Fine.
we already waived jury trial. He'd say final settlements are on 6th. But
Yeah, well,
I don't have a problem putting this in the final settlement docket if the court would allow it.
yeah, why don't I do that?
Okay.
And then,
and I'll get in touch with him and the people. If anything changes. Okay.
so what I'll do is this, I'll set the non-jury trial for February 28th.
It's February 25th.
2026 at 9. I'll set that date, but then I'll set a final settlement conference for February 6th,
Yes.
2026 at 9 a.m. And I'll list both of those as in person, but understanding that he may be in Texas.
Okay. Same here.
Yes. Okay. That was fun.